We're going to take up first, because it needs to go to finance. Senator Morrissey has a writ of actual innocence, which is similar to mine, but a little different. We hope we can get this out to finance as quickly as we can, and then we'll take up Senator Chase's bill.
SB 823, writ of actual innocence legislation. There are four main components to this bill, and then there are some floor amendments that I've discussed with staff that we'll walk you through. The first thing is this: an individual who's been convicted of a felony may petition for a writ of actual innocence based on biological evidence or non-biological evidence, irrespective of the type of plea he entered at trial. As everybody knows, right now, enter a plea of guilty, you don't have that, you can't avail yourself of that right. Often lay people would say, well, why would anybody do this? We all know that you have a charge, a horrific charge, the prosecutor charges as much and as high as he or she can. An individual may enter a plea when he or she is not guilty. It happens many times. Number two, this bill eliminates the provision that limits a petitioner to only one writ of actual innocence. Number three, the bill also clarifies that the Attorney General may join a petition for writ of actual innocence filed in an adjudication of delinquency. And finally, the bill provides that the circuit court that entered the felony conviction has original jurisdiction over the writ and the petitioner. Mr. Chairman, you and I and Mr. Benjamin discussed some amendments. Should I walk those through?
Yeah, go ahead.
Better yet, Mr. Benjamin, do you want to do it?
I'm happy to do it.
All right.
Okay, Steve?
Mr. Chairman, Senator Morrissey, first we would add the testing statute, which is 19.2-327.1 to the bill. And once added, we would remove what we discussed the other day as being unnecessary artificial barriers to an innocent person utilizing the testing. And so that would be clauses 1 and 5. The next change would be looking at the bill on line 30, the words "any petitioner who filed" would be changed to "any final decision, judgment, or order concerning." The next word in the bill is A. After A, we would insert "motion for testing" as provided in Chapter 19.1, paren 19.2-327.1, or A. On line 32, between the words "such" and "petition," insert "motion or." On the next page.
Mr. Chairman, do you want to do these in block?
Yes, do them in a block.
Very well.
On the next page, beginning line 95 to line 98, delete the language contained in subdivision 4. On lines 102 through 104, delete the language that appears in subdivision 8. On line 150, we will need to renumber those subdivisions. On line 162, after the word "granted," insert "upon request of the petitioner," so that there isn't, Senator Morrissey, an automatic expungement. Some petitioners may want the matter to remain available. On line 176, after "a petitioner," we would insert "or the Commonwealth." On lines 196 through 198, delete subdivision 4. Those would be the amendments.
Okay, is there a motion to adopt those amendments in a block? A second. All in favor of the motion, vote aye, or say aye. All opposed, no.
Aye.
Motion carries. All right.
Mr. Chairman, the last point that Mr. Benjamin mentioned, line 176, just underscore that both parties, the Commonwealth and the petitioner, may appeal. Okay. So I've talked to a couple of people. I think that may assuage their concerns. That's it, Mr. Chairman.
Okay.
And you had a similar bill, and I think you maybe desirous of rolling yours into mine. Don't want to be presumptuous, but if that's what,
It's already in finance, so, all right, we could do that later. All right, is there any discussion?
Mr. Chairman?
Yeah, Senator McDougal?
Just want to make sure I'm understanding with so this petition is not limited to scientific evidence that is now wanting to be reconsidered. It's for anything, is that correct?
correct, biological or non-biological.
Okay. And, Mr. Chairman?
Yeah, Senator McDougal?
So, and it's not limited to a plea of not guilty or alpha plea. It also includes somebody that pled guilty and had a specific plea agreement.
Correct.
Is that correct?
Yeah, okay.
Mr. Chairman?
Yeah, Senator McDougal?
So, in essence, every case that has occurred ever could do this.
The answer, Mr. Chairman, would be any case in which a petitioner can demonstrate that he is actually innocent of the crime.
Well, Mr. Chairman,
Yeah, Senator McDougal?
well, anybody can petition for this, whether they demonstrate it or not is going to be for the trier of fact, the circuit court to decide, but anybody is going to be able to make this petition, regardless of whether they're ultimately able to demonstrate it or not. Isn't that accurate?
Mr. Chairman, that's correct.
Okay. Any
So,
further?
Mr. Chairman, I just,
Senator
speaking to
McDougal.
the bill, what this will do is say, regardless of what evidence it was, there's no finality to any case ever outside of the appeals process that would have already occurred. Mr. Chairman, I think that is not the appropriate direction for us to go.
Okay. Senator Morrissey?
Just very briefly, as in response to what Senator McDougal said, one of the ways I look at this is leveling the playing field with regard to Virginia's 21-day rule and us not being able to introduce biological, non-biological evidence. If it can show that somebody is innocent, and I would say respectfully to Senator McDougal, if in fact there is evidence out, biological or otherwise, that shows innocence, it ought to be able to be shown.
Okay. Is there any further discussion? Is there a motion? Senator Chafin?
So, Senator Morrissey, is the grant of an appeal of right from the circuit court absolute?
It is?
Okay, thank you.
No, you have to petition, Mr. Chairman.
Well, that's what you meant.
Right, but
Soon the person
every
petitions.
every case, regardless
Do you have
of
a
how-
right to petition?
Right,
Yes.
and one more question.
Yeah, Senator Chafin?
Regardless of how ridiculous a claim might appear on its face, they would have a right of appeal to the circuit court.
Correct.
And one more question.
From a
And
court of non-record to a circuit court, and in the circuit court to a court of
Court of
appeals.
Appeals. Thank you.
Okay. All right. Is there a motion?
Mr. Chairman, are we
Yeah.
not going to hear from the public on this?
Yeah.
We've certainly
Okay.
offered a
All right.
lot of
Everybody,
changes.
who would like to speak in favor of the bill? Anybody would like to speak in favor? Anybody speak against the bill? Well, coming up.
My name is Scott Campbell.
2 minutes. Go ahead.
I'm the nephew of Anna Jean Anderson, who was a victim of one of the most violent and abhorrent crimes ever recorded in this state on September the 4th, 1996. Her killer has been incarcerated in the Virginia prison system for 23 years, serving a life sentence without parole that was adjudicated in its totality on August the 27th, 1998. Senator Morrissey was kind enough to explain to me this morning that there have been changes to this bill after, we spoke about 511 last Wednesday night, but I am just a lay person, and for me to begin to understand this litany of codes and lines and subsections and subdivisions and changes is kind of, well, it's outside of my scope, that's for sure. But one of the things that Senator McDougal has raised, and I'm here to say again, my family and I are family members of a victim of a violent crime. It was adjudicated on DNA evidence. There was also a great deal of conjecture about fingerprint evidence. But the fact of the matter is only one of the two people in that house was raping my aunt while he was murdering her. And that's the only evidence in that house that he was in there. So if you grant him unlimited appeals, not only will our family be going through the same hell we've been going through since about August, waiting on a Malvo ruling to even determine whether this guy gets a resentencing or not, but now you're saying it's unlimited opportunities for him to make up whatever he wants to continue his effort to try to get out of jail, which is all he cares about. It's all he wants. It's his only goal set. And he's got a 650-man law firm helping him, and I'm just me.
Okay.
So hope you guys make some better decisions in the future.
Okay, thank you. Anybody else? We got, okay. Are you ready?
Mr. Chair.
Yeah, Senator
Peterson.
Peterson.
A question for Senator Morrissey. Is this unlimited appeals, or is this one bite at the apple? I mean, how many times can you raise this writ of actual innocence?
The former unlimited, it used to have one bite of one bite of the apple. And you may remember initially when the writ of actual innocence legislation was proposed, it said, use the language, no jury could, and we changed that to would several years ago. I actually worked on that with then Attorney General Cuccinelli. But this gives the person more than one bite of the apple. Now they have one.
Mr. Chairman, Senator Morrissey, one reason, and Senator Peterson, one reason that's important is because science continues to evolve. And so a petitioner might have one form of DNA evidence that suggests that he's innocent, file his writ, be denied, and then as science and the ability to type smaller and smaller samples evolves, he might have a new testing methodology that is available at the Department of Forensic Science that he can then use to definitively demonstrate his innocence. That's why it's important.
Mr. Chair. Mr. Chair.
All right, Senator Peterson.
And I understand that, but I guess what prevents somebody from filing a writ of actual innocence every 30 days? I mean, this, as the gentleman just testified, this could be ad nauseum. People just keep raising the same issue and over again, and there's no limitation on it.
Well, Mr. Chairman, I think the answer, Senator Morrissey, is that the state has proven to be quite adept, the Attorney General's office, at dealing with writ filers. They're known in the DOC. There are certain personalities who will always do this, but the Attorney General's office is quite capable of dealing with them.
Okay. All right, yeah. No, you already spoke. Anybody else like to speak? You got a question, Senator Obenchain? It's now 8:21. We're on one bill.
I do understand that, Mr. Chairman, but given Mr. Benjamin's last comments, how on earth does this not have an enormous fiscal impact?
It's got to go to finance.
You can't just have people.
Okay. All right, anybody else? Is there a motion?
Mr. Chairman, I just
Senator McDougal.
want to remind the committee, Senator Peterson and Mr. Benjamin's comments were focused on biological evidence. This is not limited to biological evidence. So this is going to open up anything anybody says or wants to petition, and it's going to happen repeatedly. This is not the direction that we should go. There are victims of crimes, rape, robbery, murder, carjacking, that are going to be subjected repeatedly to this process. Mr. Chairman, I think that there are some legitimate things that we should look at for writs of actual innocence, but this is just totally opening the door and will re-victimize individuals over and over again.
Okay, is there a motion? Been moved to pass it by indefinitely. Is there a second? Second. Second. All right, that's the motion. All in favor of the motion to pass it by indefinitely, vote aye. All opposed, vote no.
I'm throwing you a lifeline, Joe.
Aye, 6, no 6.
The motion fails. Is there another motion?
Move the bill be reported.
The motion to report the bill, report the bill and refer to finance. All in favor of the motion to report and re-refer to finance, the substitute. All in favor say aye, vote aye. All opposed, vote no. This is the report and re-refer.
Aye, 6, no 7.
6, no 7, the bill fails. All right, thank you.
Thank you, Mr.
All right, next, Senator Chase, been waiting there. She has a bill. She's not on the committee, so we're going to take her bill up. Which number is this?
Thank you, Mr. Chairman. This is Senate Bill 999.
999. All right, pay attention to the patron.
And before we begin, I would like to actually have some amendments to this bill that changes lines 131 to 135 to allow law enforcement agencies the option of extending the investigation period for an additional 90-day period, so if that could be passed out. Mr. Chairman, members of the committee, I guess you're going to adopt this substitute or amendment before I move forward.
It's been made and seconded to adopt the substitute. All in favor say aye. All opposed say no. Aye. The motion carries. If anybody's voting. I think it passed by 2-0, I think. Go ahead.
Very good. Thank you, Mr. Chairman. This is a bill that helps our law enforcement officers. It's a procedural guarantee act. It makes several changes to the process and procedures afforded to law enforcement officers under the Law Enforcement Officers Procedural Guarantee Act, clarifying several existing rights and setting forth specific procedures for the questioning of officers and the conduct of a disciplinary hearing. And I would like to add, Mr. Chairman, that I'm submitting this bill at the request of the Fraternal Order of Police. What I would like to say here is that this bill adds additional layers of due process to the code and does not take away any rights that the victim would have to make a complaint. It adds more layers to the of protection of the police. It gives officers a lot more reasonable chances to respond and puts a 1-year statute of limitations on how long an agency can bring a complaint forward. It gives the officer 24 hours notice prior to being questioned, so the officer has the ability to talk to their representation or the representative and to their attorney. And it actually cleans up some procedural wording of 9.1501 and 30-day grievance response period and 9.1502. Police recruitment of qualified applicants is down nationwide, and there has been a substantial increase in attacks on law enforcement. These factors, in addition to low pay, the institution of body cameras, and scrutiny of law enforcement's actions, provide few perceived benefits or incentives for entering the police profession. As our law enforcement officers are entrusted with the abilities to lawfully effect an arrest and deprive an individual of their freedom, in a society based on liberty and ultimately utilize deadly force and lawfully take the life of another, we must ensure that we are recruiting and employing the very best applicants. These potential actions require that our laws protect the individual rights and afford the officer adequate representation. The current police officer's procedural Bill of Rights outlined in Virginia Code is circumventable and in some sections vague with regards to an officer's rights, to include the right to counsel. For instance, the code states that an attorney may assist the officer in making a response to charges, but does not definitively spell out rights to counsel during interrogation or questioning prior to a formal charge being put forth. Officers need representation through an advocate not employed or influenced by their employer to look out for their rights and best interests. There's no recourse outlined in the current code for an accused officer if it is determined that the department violated his or her procedural rights under the code. Some departments require an officer to sign a garrity form which prohibits the officer from discussing the investigation with other persons. This places the officer at a disadvantage as she is unable to gather factual information to mount a proper defense. A department may change specific wording as a way of denying an officer their rights under this code section. For example, an inquiry or allegation does not trigger certain rights afforded to an officer who has been formally charged. Transparency and sharing of evidence is necessary for inherent fairness to both the officer and the department. Some departments prohibit officers from recording investigatory interviews and deny the officer access to the evidence against them. In our adversarial judicial system, the defense is entitled to examine the prosecution's evidence against them, as well as confront witnesses to ensure truthful testimony. My final point, Mr. Chairman, is this is not a union bill. It simply affords police officers with representation and procedural fairness in an ever-changing and increasingly hostile profession. If we want safe communities, we need good police officers. The terms right to work, employment at will, and no collective bargaining puts Virginia at a national disadvantage as the Commonwealth competes with other states for qualified police applicants.
Okay. Any questions of the patron? Any questions of the patron? Yes, yeah. Charles?
Mr. Chair, there is one additional amendment in the substitute. On lines, in the original bill, in the introduced bill, on lines 85 to 87, there was a grant of use and derivative use immunity, and that provision has been taken out in the substitute.
Okay. Okay. So it's the grant of use immunity.
Mr. Chairman, there is no immunity. As the patron mentioned, Garrity does provide enough protection for law enforcement officers so they're aware that any statements they made can be used to incriminate them. So the immunity provision was I don't want to say a bit of a bridge too far, but it was taken out.
Taken out, yeah, okay.
Mr. Chair, can I ask
Yes,
counsel a
yes,
question?
Senator Deeds.
On line 61, the phrase "effective counsel," does that appear anywhere else in the code?
We'll have to check that.
Right, nobody knows.
Mr.
Okay, Senator
McDougal. Mr. Chairman, this is also for Charles or Steve. Am I, just because I'm trying to read through the substitute, is this limited to an action of discipline, or would that 24 hours notice and all other requirements include any criminal act that could be in play as well?
Mr. Chairman, Senator McDougal is exactly right. This would apply to any criminal investigation as well.
So, Mr. Chairman, that's
McDougal.
what I was afraid of. I just gotta say, I heard the words non-union bill, and I've heard this is just a protection, but the law enforcement should not have any different rights than the public. And if there's an allegation of a criminal act, they should be able to be questioned. They have their constitutional rights to the Fifth Amendment. They have their constitutional rights to the Sixth Amendment, and they should invoke those if they need. But they should not get a special right that it's not to be discussed or investigated 24 hours without 24 hours notice. I don't think that's appropriate.
Any other questions of the patron? Or do you have anybody who wants to speak in favor of the bill? Yeah. Yeah. Okay, anybody wants to speak in favor of the bill?
Mr.
All right,
Chair.
anybody want, Senator Peterson.
And first of all, I want to thank the patron for bringing this bill, and I read it pretty closely. I agree with Senator McDougal. It puts a whole lot of restrictions on investigating police conduct, which, if I talk to my employees, and I'm not aware of any other small business or agency that would not be allowed to talk to their employees effectively to find out what happened. So I just think this needs to go by for the year.
All right, is
I'll
there,
make that motion.
anybody would like to speak against the bill? I want to let the public have what they have to say. Okay.
Mr. Chairman, members of the committee, I'm Mark Siegel with the Hanover Sheriff's Office. I'm also speaking on behalf of Dana Schrod
I can't hear you.
Dana Schrod with the Chiefs Association. So we already have Garrity, 1967 Supreme Court case that says that anything that we ask a police officer in an administrative hearing can't be used against them criminally. That's the substance of Garrity. And then secondly, we also have the 9.1500 series in the Code of Virginia to protect police officers. Getting to the heart of the truth in an administrative matter when it comes to police officers, we can't give police officers the right to an attorney just for an administrative investigation. It'd be no different than, I think it was Senator Peterson that said that if you had a small business, that they would have a right to an attorney. We're against this for all the reasons that have been discussed by the other senators.
Anybody else? Okay, all right. Nobody else wants to speak? We have a motion. What's the motion? Motion to pass it by indefinitely. Is there a second? Been seconded. Is there any further discussion on the motion? All in favor, vote aye. All opposed, vote no.
All right. Thank you, Mr. Chairman.
Okay.
Ayes 11, noes 3.
11-3, the bill is passed by indefinitely. Okay. The next bill up is, we'll do it in order, I guess. Chafin? Stewart? Okay, Stewart, all right. Stewart, is that Senate Bill 133? Huh?
Thank you, Mr. Chairman, members of the committee. I have 133 first. And, Mr. Chairman, what that bill simply does is it allows a court to take a case under advisement if an individual has been diagnosed on the autistic spectrum or with an intellectual disability. And you all have voted for this bill before. I believe this bill has passed the Senate time and time again to get caught up in House courts. When I was a Commonwealth's attorney, I was a Commonwealth's attorney for a small part of my time I practiced law, and I've done defense work for the other 20-some years. But the thing that just tears me up the most is when you get a young person with developmental disabilities or on the autistic spectrum. They're not insane, but they don't understand the world like you and I do, and the judge doesn't have the flexibility to take that case and to try to help this person. We've had some awful examples that have come out. I'm aware of one child in Stafford County where he was at a park and the officer approached him to question him. And a lot of times children with autism, they only understand two things, fight or flight. And so they'll either run away or they'll stand their ground. And unfortunately, this child stood their ground, got into the system, got into jail, and it was a nightmarish thing that happened. You all can recall Governor McAuliffe tried to get involved and help. And we see a lot of these examples, and I know a lot of people aren't fans of advisements. But if you're going to have an advisement, these are the people we ought to have them for.
Hey, Senator Dees.
You know, when we passed legislation last week or week before from Senator Servell that would allow deferred dispositions, and you've got a couple of other bills on the docket, 286 and 309, which appear to be broader than yours. Isn't that right? Or
probably, I can't disagree with you. I don't know.
Okay. Anybody, any further questions of the patron? We have people to speak in favor. Okay, step right up. We'll give them 2 minutes.
Good morning. Thank you for this opportunity to speak. I'm Jude Harrison. I have a son, Drew, with autism, who got caught up in the criminal justice system. I'm also the director of communication for LRID, a national organization which began here in Richmond. We advocate for legal reform for people with IDDD. Brian Kelmer, the co-founder of LRID, began speaking about injustice that his son endured. When he asked to speak via a webinar, we were prepared for 100 to 150 people. After over 1,000 people signed in, the site crashed. It was obvious that this is a huge issue for thousands of people. Today, I want to speak on behalf of my own son and others who can't be here today. My son has told me that from the moment the police arrived, he was clueless as to what was going on. His confusion would continue throughout the entire legal process. Like most with autism, Drew's chronological age was 25, but his emotional and developmental age was 13. 1 out of 59 people being diagnosed with autism, it's urgent that our criminal justice system begin to take this into account. In a civil society, we do not hold a child to the same standards as we do an adult. Again, we must consider the age difference and developmental difference. Judges are given the power to judge, and I feel that they must be given the discretion to consider alternatives. During 3 separate court hearings, the judge in our son case said
25 minutes,
that Drew...
25 seconds to go for everybody. Go ahead.
I don't think there's any opposition to this. It's just a question of figuring out what, Mr. Chair, I was...
Senator Deeds.
Senator Stewart, your bill Senator Stanley has a bill, I have a bill. Do they all fit together?
Mr. Chairman, I can't answer that, but what I'd love to see is this one move through the system. And as I'd hate for the broader bill to not make it, and that's my only concern. Everybody likes
Stewart,
this bill.
Can we take this by temporarily to see if we can mesh them together? Sure. And 3 bills together? What?
The only thing that concerns me, Mr. Chairman, is this was drawn for children, not children,
Okay,
but
all right.
people with intellectual
Chair.
disabilities. And if the bigger bill
Okay.
fails, I'd like for this one to still be alive.
What?
Yeah,
Okay, is there a motion? All right.
The docket, Mr. Chair, the docket says that has fiscal impact. I wonder if the report, if the motion has to be.
There's no fiscal impact,
there's no
Mr. Chairman.
fiscal impact.
No fiscal impact.
Deferred disposition.
Just, what's that? No, it does not need to go to finance. All right, is there a motion?
I move to report.
Second, all in favor of the motion to report the bill, vote aye. All opposed, no.
Thank you all.
Okay.
Ayes 14-0.
Ayes 14-0, the bill is reported. Senator Stewart, you got another bill?
Yes, Mr. Chairman, Senate Bill 148. And so, Mr. Chairman, those that are lawyers and maybe some that are not are familiar with a case called Seraphin versus Commonwealth. And what that case said essentially, I'll let the expert on the far end, Senator Serval, explain and answer any question. But essentially what that case said from the Supreme Court a few years ago was that you could be arrested and prosecuted for DUI on private property. Now, you cannot, they cannot use implied consent, and they can't force you to take a breath test because you're on private property, and that's limited to public property. But here's what happens, and I've had this case, I've seen these facts. A person can be sitting in his or her own driveway with the keys in the ignition, playing the radio, drinking a beer or two with no intent to go on the highway. The officer, based upon complaint or based upon the open fields doctrine, can stop and say, hey, what are you doing? And proceed to question, proceed to ask him or her to take field sobriety tests, and have him charged, arrested, and prosecuted for DUI. And I just don't think that's what we intend.
Okay, any questions of this patron? Okay.
Mr.
Steve?
Chairman, I have a technical amendment.
Steve, got a technical amendment.
Looking at line 48, instead of the language on his own residential property or the curtilage thereof, because I think those are both the same thing, I would suggest after the words motor vehicle, substituting this language, on his residential curtilage or his adjoining property.
I would move that amendment.
Second, all in favor of the motion, say aye. Aye, all opposed, no. Motion carries.
And the same thing on line 28.
Okay. Anybody want to speak in favor of the bill? Anybody want to speak against the bill? Okay, here we go.
Insurance companies don't like it.
I'm Kurt Erickson. I'm here both for the Virginia-based Washington Regional Alcohol Program, also Mothers Against Drunk Driving, in opposition to this bill. At best, our feelings are that this bifurcates Virginia's DUI laws, that's saying that it's okay to drive drunk here, but not here. And at worst, it does what the Virginia pilot said about this very legislation when it was introduced 2 years ago, is that it's chipping away at Virginia's DUI laws. Thank you.
Okay. Next, go ahead, Senator Sessler.
Somebody a couple of years ago told me that you could be arrested for drunk driving on your own property with a rider lawnmower.
Exactly. Yeah.
That's correct.
How much safer have we made America by keeping that on the books?
I guess our concern is, unless I hear that the court dockets around the Commonwealth are swollen with these type of cases, I'm not too sure that it's a problem. I hear what the concern is, but I'm not too sure that we're...
May I ask you a question?
Yeah, Senator Peterson.
So if someone is freezing to death and they're intoxicated and they get inside a vehicle and turn on the heating system so they can stay alive, are you telling me that they should be subject to prosecution?
It more speaks to the...
I think a yes or no will suffice, sir.
Well, but I think it speaks to the Seraphin judgment, which is how they define the operation of the vehicle. And in that case, they said
But I
that
think they've already defined it as if once you click the
Correct.
engine over, then you're operating the vehicle.
Correct.
Well, I disagree with that.
Okay, all right, next, got another opponent here.
Good morning, Mr. Chairman.
Minute, 30 seconds.
Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, here speaking on behalf of Virginia Association of Commonwealth Attorneys. Our major concern, in addition to what has just been spoken to, is this change would make us not substantially similar to other states' laws on DUI. So now DUI second offenses, DUI third offenses are much more difficult to prove. Well, they're not, you cannot prove them with out-of-state convictions. We are no longer substantially similar. Again, the individuals that are driving their lawnmowers, the individuals that are listening to the ball game in their parking lot, We're not seeing them on our dockets. This bill would also open up that individual who has, and some individuals in Williamsburg have large parcels of land, and they do drive on it. If they drive on that large parcel of land intoxicated and run over a neighbor, they would not be subject to prosecution either.
Mr. Chairman.
Again, just
Okay,
too far.
Senator Peterson.
No, it's me.
No, Senator Sherwood.
Mr. Chairman, if you listen to the oral argument, the Supreme Court, which decided this case 4-3, Chief Justice Kinzer at the time asked the Attorney General's office, do you mean to tell me that if I'm sitting on the side of a mountain in my RV with the thing turned on, bothering nobody just to keep warm, that should be illegal? And the Attorney General said yes, and she said that's preposterous. And it was a 4-3 opinion. I think the policy choice is pretty clear in this. I mean, I'm not sure any additional testimony is going to move this needle one way or the other. I think we need to move it along.
Senator Morrison.
Move to report the bill.
Is there a second to report the bill? Any discussion? All in favor of the motion, report the bill, vote aye. All opposed, no.
Thank you, Mr. Chairman.
Yeah, thank you.
Ayes 12, noes 1.
As 12, noes 1, the bill is reported. Okay, we go down the list. Senator Chafin, Senate Bill 1003.
Mr. Chairman, members, this bill, Senate Bill 1003, is a bill that would close a loophole in current Virginia law that allows an individual to maliciously use an internet-capable device to perpetrate a costly or really potentially devastating fraud on unsuspecting people. And it comes to me from an actual case that occurred with a couple in California who had advertised on social media. They were having trouble having a pregnancy, many miscarriages, infertility, and they advertised for that they would like to adopt a child. And they were contacted by a lady out of Wise County, Virginia, who told them that she was pregnant and looking for an adoptive placement for her unborn child. She sent them pictures of an ultrasound. She sent them pictures of a stuffed unicorn and a recording that she said was the baby's heartbeat. After a lot of correspondence, they made plans and paperwork drafted, hired an attorney to complete an adoption. They traveled from, and I said Wise County, it was actually Scott County. They traveled from California to Scott County 3 times. Made arrangements for a birthing center, made a lot of elaborate, expensive arrangements for the birthing of this child. And then later that year in 2018, the perpetrator notified them that she was in early labor and something was wrong, and sent them pictures, and I don't mean to be indelicate, but of bloody toilet sheets, that type of thing. And they flew to Virginia again with their 6-year-old son, and during that very emotional exchange, she admitted she had made the whole hoax up, and that she had done it. She was on probation, and she had done it for the reason that I wanted someone to feel pain like me. And so there's nothing on our books that would allow this to be prosecuted.
My notes indicate that it's already a crime. Is that right, Counsel? 18.2-152.3. It's a.
Mr. Chairman, we did have that question. 18.2-178 is what's known as the false pretenses statute. It criminalizes a person who obtains by false pretense with the intent to defraud money, a gift certificate, or other property. The difference, as I see it, between between the statute and the bill is that the statute, you have to obtain the money. Under the bill, you need only cause someone to expend money.
That's it. That Mr. Benjamin's right, Mr. Chairman. In this case, it's not a defense that you didn't receive it would not be a defense that the defendant didn't receive any direct or indirect benefits. That was the problem. There was nothing obtained other than this bizarre intention to create a hoax. And so this would not have been a crime.
All right.
The concern I would have, Mr. Chairman, not meaning any harm to the bill, because I understand the intent, is that we haven't adequately defined hoax. So I'm concerned that the word hoax could be extended to a legitimate enterprise, say a political campaign. A political campaign might engage in such hyperbole that it causes people to donate money that they would not otherwise. They could later then maintain that it was a hoax, that the candidate was not the second coming, so to speak. That's my concern, that the word hoax should probably be more narrowly defined or more specifically defined.
All right, okay. Is there anybody who'd like to speak in favor of the bill? I think we got somebody who wants to speak in favor of the bill.
Good morning again, Mr. Chairman. Nathan Green, Council Attorney for the City of Williamsburg and James City County. At this time, I'm speaking on behalf in my personal capacity as Commonwealth Attorney, and also speaking for the Commonwealth Attorney in Wise County, Mr. Chuck Slemp. And we are in favor of the legislation. Mr. Benjamin has cited the differences between the existing law and what this bill would do very well. In this case, the individual was able to be prosecuted, but it was only because they went to dinner. She received some benefits, she received some dinner, she received some photographs, and they were able to prosecute her under the false pretenses. If it had not been for that, however, if it was just the con, she would not have been able to be prosecuted. And so we are asking for this bill to pass.
Anybody else want to speak in favor or against the bill? Any further discussion? Yes, Senator Stewart.
Sorry about that. Ben, I'm curious, could you prosecute somebody under the business tort theory for something like this? Where they are doing it to injure your trade or business, or is that outside the realm? I mean, I understand what you're doing here. I'm keyed in on what Mr. Benjamin said, but there is a business tort for injuring one in their trade or business. And wouldn't that cover this? Even if you did it on the internet, if you're creating a hoax and it's, I don't know the answer, but it seems to me it would be covered under that statute. That's a Class 1 misdemeanor, and there's treble damages associated with it, I believe.
Well, Mr. Chairman, you would have to be shown to have malicious intent. Okay, and malice.
Well, you could probably show the tort of interference with the contract through common law too.
Mr. Chairman.
Yeah, Senator Obenshain.
That Business Conspiracy Act requires a conspiracy.
Yeah.
I mean, it can't be one person. It has to be a conspiracy.
Yeah,
So I don't think that's applicable.
Yeah, different section of the code. All right, any further discussion? Is there a motion?
I move the bill.
We do have one better word we came up with instead of hoax, the word scheme. We do use the word scheme throughout the criminal code. That is a little bit more definite than hoax. And if your bill includes false pretenses, it might be a scheme involving false representations. Would that do harm to the bill?
I would accept that as a friendly amendment.
Just moved and seconded to change the word hoax to scheme.
Scheme involving false representations.
The scheme involving false pretenses.
False representations.
False representations.
All right. It's a scheme involving false representations in lieu of hoax. That's the motion. All right. Been moved and seconded. All in favor of the motion say aye. Aye. All opposed, no. Motion carries. And there's a motion on the bill.
Motion on the
bill. Been moved and seconded to report the bill as amended. All in favor of the motion vote aye. All opposed vote no.
Ayes 11, noes 1.
Ayes 11, noes 1. The bill is reported. All right, Senator Deeds, where'd it go? Okay, we're going right down. I got several bills I'd like to present now, since we're doing it alphabetically. Where's Senator Deeds?
John Gibbons, 375.
I'm sorry? What's that?
Mr. Chair, do you want me to do Senate Bill 375?
Yeah,
That's your bill.
Yeah, that'd be fine. Senate Bill 375.
Okay. Mr. Chair, members of the committee, Senate Bill 375 was in the Civil Subcommittee on last Monday, and we came up with a substitute, which I'd like to have distributed, and then I'll explain it. If I can move, we adopt the substitute.
I move the substitute.
Second. Thank you. Have we adopted the substitute?
It's been moved and seconded to adopt the substitute. All in favor of the motion, say aye.
Aye.
Aye. All opposed, no. Motion carries. Substitute's adopted.
Thank you, Mr. Chair. This is a bill that you sponsored, and it has a lot of interested groups, including ACLU and a lot of other folks that are in the audience. I want to thank them for participating. We had a very long subcommittee hearing on this, and basically what I'm showing you is sort of the consensus of the subcommittee panel, which is taking the existing statute, which deals with immunity of statements made at a public hearing, which are by definition First Amendment statements, and protecting persons that make those statements if they later become the subject of a civil lawsuit. It takes what's the existing defense and puts it in the posture of what we call a special plea, which would then be litigated at the outset of the case. Discovery would be suspended in the case, other than that discovery which goes directly to the merits of the special plea. There'd be an order entered on the special plea, and if the defendant is successful by pointing out that this is protected First Amendment speech and there's no evidence that it was a willfully false statement, then the case will be dismissed. If, however, the plaintiff is able to have the plea overruled, then they will proceed with civil litigation just as they would in any other context. What I think is important, and we had a lot of discussion on this, is that if done incorrectly, this statute could be a bar for almost any civil case because it would be an avenue for deep pockets defendants to sort of throw motions at people and take them up on interlocutory appeal and prevent the courthouse door from being open for very valid plaintiff's cases. But I think we've really screwed the language down pretty tightly so that it just goes to First Amendment protected speech, which again is speech made in a public hearing or a matter directly of a public concern and protected by the First Amendment. And by having the special plea and by keeping this very tightly wound to that special plea, I think we got to a good place. And so having given that overlong explanation, I would move that we report the bill.
Mr. Chairman.
Mr. Chairman. Senator Overton.
Just before move on that, my only question, and I think this is maybe not a bad way of proceeding with this, but changing the may to shall on attorney's fees, I mean, I recognize parochial interests here, but what always concerns me is that people are going to not file a good faith complaint or defend a good faith claim because of the potential for the award of attorney's fees. And where it's mandatory, you may very well have a situation where you're acting in good faith. It's a close call, could go either way, but because you know that you're going to get socked with and can't afford the attorney's fees, you've got a potential litigant who may be on the side of the angels, who is not going to pursue that case or that defense because of the mandatory nature of the attorney's fees. I would hope that we would maybe reconsider that and maybe
is that a motion?
Consider a motion to change that back to may.
It's been a move to amend shall to may in attorney's fees. Is there a second? Second. Is there any discussion? All in favor of the motion to change shall to may in the attorney's fee provision, vote aye. Say aye. All opposed, no.
Mr. Chairman.
Okay, the ayes have it.
Mr. Chairman.
Yeah, Senator Searle.
Thank you. I have another amendment. So, and I discussed this with Senator Peterson. I'll then bring it up with you. But the way I read the statute as it's written right now, subsections A and C are substantive law, and subsection B is procedure. And in order to ensure that this statute or defense is capable of being applied in federal court, I think that we need to add on at the beginning of subsection B something like in any proceeding in a state court, comma, just so it's clear that A and C can apply in a federal proceeding as substantive Virginia law. and B, just deals with process about how you do it in a state court.
Doesn't that kind of get into the weeds too much? The federal judges understand that.
Yeah. I had this conversation with my former law partner last night, and I don't necessarily agree with him. I think anything we do is obviously tailored to state courts, and obviously if the feds use our federal substantive law, that's up to them.
Would you like to withdraw the motion?
No, I wouldn't. And I'm speaking to the motion, I disagree. I mean, federal courts apply substantive Virginia law, and if we create a defense that provides for attorney's fees in a proceeding, if we adopt this and it only applies in state courts, then everybody will file these slap tourism cases in federal court instead of state court. That's why it's needed.
Moved and seconded. All in favor of the motion, say aye. All opposed, no? No. I say, if you want to go on the board or not, I know it's my bill. That particular motion is denied. Okay, is there a motion to report the bill?
I move to report the bill.
Is there any discussion? I second that. Any discussion? All in favor of the motion to report the bill as amended, but aye.
Ayes 14-0.
Ayes 14-0. The substitute is reported. I got 3 other bills, and then we'll go to Senator Deeds. You're in charge.
Is there a motion we rise and let the rest of these bills linger?
What was that?
Senator Edwards.
I would like to start out with, let's see, the Senate Bill 494. This is a bill that deals with the crisis intervention teams. It simply adds the Department of Aging and Rehabilitation Services and brain injury stakeholders to the list of entities with whom the Department of Criminal Justice Services is required to consult in developing a training program for all persons involved in the crisis intervention team programs, and requires a curriculum for such training programs to include a module on brain injury. That's all it does.
Move to report.
Open the roll. Or unless there's any public discussion, apologize.
Mark Siegel again, Mr. Chairman. We already do this training, and we can't imagine any CIT model that does not incorporate brain injury as a module in the training we support.
Yes, ma'am.
Mr. Chairman, Becky Bowers Lanier with the Brain Injury Association of Virginia. We support this bill. We asked the senator to carry it for us.
Okay.
It is not widely done throughout the state.
Thank you, ma'am. We've got a motion and a second. Open the roll.
Mr. Chair, there is a slight technical amendment first.
I apologize.
I believe on line 18, after the word injury, the and should be stricken and insert as part of.
I move that amendment.
So you're taking the and out and you're putting as part of the.
Correct. So the training would be incorporated in the 4 hours that currently exist.
Okay, there's a second or there's a motion and a second on the amendment. All in favor, aye?
Aye.
Any opposed? Okay, the bill's amended. There's a motion and a second to report. Open the roll. Okay.
Ayes 14-0.
Okay, Mr. Chairman, you've got another bill.
Yes, the bill is reported as amended. Senate Bill 997 deals with venue, requested by Steve Whitmer, the Division of the Capitol Police. I think he may be here. This simply means that anybody who threats or harasses or the governor-elect, lieutenant governor-elect, attorney general-elect, or a member or employee of the General Assemblies of the General Assembly, you and I, a justice of the Supreme Court of Virginia, a judge of the Court of Appeals of Virginia. In addition, threats to damage property that may be prosecuted in the city of Richmond if the property is owned by the Commonwealth may also be prosecuted in the city of Richmond, wherever it might otherwise occur. That is, if it occurred outside the city, it could be prosecuted within the city of Richmond. It's a venue issue.
Mr. Chair,
Senator Peterson.
so if somebody comes to my town hall in Fairfax City, and they're a resident of Fairfax City, and I'm a resident of Fairfax City, and they excoriate me up and down, justifiably, I might add, for my voting record, speaking record, everything else, that I can then haul them down to the city of Richmond and sue them under this statute?
It could be prosecuted, yes, in the city of Richmond.
I'm not vote for this.
Mr. Chairman, members of the committee, Captain Steve Whitworth, the Division of Capitol Police. This bill is primarily a response to technology because it is sometimes difficult to determine where a threat is made and where it is received, both because of cell phones and because of the internet, message boards, the use of virtual private networks, and so on. We had an instance last year where there was a threat made to blow up the state capitol. That threat was that? No. That threat was directed at a state agency here in Richmond, but it was actually received at a telephone center located in another state. They had hired a contractor to manage a call center for them. So the call was received out of state, and the only reason we were able to determine a venue in which the case could be prosecuted was because when questioned, the suspect admitted what county he was standing or city he was standing in when he sent the text message. So this is just to provide an alternative venue. That's all the bill does.
Senator Stewart's got a question.
Based upon that, and I understand what you're trying to do, why couldn't we say in which the communication was made or received, and if unable to determine that, then in the city of Richmond? I think there's some concern about there being a decision for all these to be prosecuted in the city of Richmond, and just leave that as a default.
But, Mr. Chairman, members of the committee, it's the senator's bill and will of the committee.
I would resist that. I mean, he gave one example, but there could be other examples too.
Mr. Chairman?
Yeah.
Senator Morrissey.
Senator Edwards and staff asked the same question. Aren't there already a plethora of situations where an individual communicates a threat over the phone or internet, and the existing law is that the person can be prosecuted where the threat was made or where the threat was received? Is that not correct?
That may be the case, but I would say sometimes you don't know where it was made or where it was received. With the internet, you don't know where it's coming from, or you don't know where it's going. I mean, the internet changes everything in terms of location, physical law is always location specific, and the internet has changed that.
Okay, I think Charles has some suggestions.
Mr. Chair, there are 3 suggested amendments, and they're all the same amendment, but it would limit the application essentially on line 40 after Commonwealth, and such official or employee was threatened while engaged in the performance of his public duties or because of his position with the Commonwealth. Because the bill doesn't tie it to their employment, and it does make note of legislative employees, someone like Steve Benjamin could be threatened unrelated to his responsibilities here and would allow somebody to be hauled into Richmond for it.
And that amendment would be on line, or at the end of the italicized language on 43, or no?
On lines 40, 69, and 77, Mr. Chair.
Lines 40, 69, and 77.
Okay.
The same language.
Is there a motion on that?
I move that amendment.
Okay, a motion and a second on those amendments. Are all in favor, say aye. Opposed, no. Okay, the amendments are adopted with one no.
Mr. Chairman.
Senator McDougal.
So is this all because the governor set up a call center to take constituents' calls out of state, and that's the issue? Mr. Chairman, I mean, because in my office, if somebody calls, the venue is going to be in Hanover County.
Mr. Chairman, members of the committee, I can tell you that the specific instance I related has nothing to do with anything done by the governor. This was another executive branch agency that had set up a call center because they have a large number of calls, and it made sense to have them handled by a contractor.
Mr. Chairman.
Yeah,
Senator McDougal's
So,
another question, then
well,
Senator McClellan.
Well, it concerns me that a branch agency set up a call center not in the Commonwealth of Virginia, so that's number one, but a different day. Mr. Chairman, when we're looking at criminal cases, we are certainly have a higher standard, and we've had this, so I think my position is fairly consistent. It should be where the offense was committed. And Mr. Chairman, if the government can't prove that it was committed where the call was received, or the communication was received, or whether it was made, then it shouldn't be prosecuted in Virginia. It should be prosecuted somewhere else. And I don't think just because somebody is serving in a particular position of responsibility that they should get a different preference. Just like I said for law enforcement earlier, there should be no difference. And if a citizen of the Commonwealth received a threat and they couldn't figure out that it was made for, received in Virginia, why should elected official be different?
Senator McClellan.
Thank you, Mr. Chair. I just point out that this bill is addressed to more than just calls. The issue is if there is a threat from a text message, from Facebook, from Twitter, you cannot always determine where the person that made that threat is physically located when the threat was made. So that's the issue the senator is trying to address, not just did somebody make a threat with a telephone call. Now, whether that should be true for everything is something we need to decide, but this specific bill is about more than just telephone calls.
Mr.
Well,
Chairman.
let me ask a question. If I'm sitting in my law office in Hot Springs and I get a text message that says, Deeds, I'm going to kill you because of some vote you made, and I know who sent the text, I could, under this bill, prosecute the case either in Bath County where I live, in the jurisdiction where the perpetrator lives, or the city of Richmond.
In all likelihood, it'd be where you live, but it couldn't be prosecuted twice.
Okay. Now, Senator Morrissey, yeah.
Captain, if I could ask you a question.
Mr. Chairman,
So listening to Senators McClellan and Deeds, I understand the following. It may be difficult to determine where the message was sent. I get that part. But don't we know with certitude where it was received? It was either received in Bath County, or it was received out of state at a call center, or was received, I mean, in order to have that prosecution, you have an individual who's making the complaint, and they say, I was sitting such and such when I got this threat. Isn't that true?
Mr. Chairman, members of the committee, that is not always true. For example, Senator, if you were to be here in say you were in Prince George County, and while you're in Prince George County in your car, you call your office voicemail to retrieve your messages, and the message the threat is on your voicemail. Is the threat on your voicemail, is the threat received in the city of Richmond? Is the threat received down in Prince George County?
No, I'm going to go to Richmond officials and I'm going to say, whilst I was in Prince George County, I received a threat in the city of Richmond. Prosecution would be in the city of Richmond. Prosecution would be where the person sent the threat. The fact that I happen to call from Prince George County is irrelevant. But the whole matter comes up for a prosecution because somebody said, I received a threat. I'm just concerned about, two things. The carve out because we're in certain positions. That's number one. Number two, where adding another jurisdiction, Richmond, where you can prosecute it. I just tend to side with Senator McDougal in this, that if you can't prove where it was sent or where it was received, I'm sorry, governments, then you don't prosecute the case.
Are there additional questions for the patron of the witness?
I would only say in closing that the internet has changed everything in terms of location, physical location. And this at least allows us to be prosecuted in the city of Richmond for people who are involved in government service.
Okay.
And I move that the bill as amended be reported.
Is there a second? I'll second. Okay, we've got a motion to report and a second. Is there any further discussion? Open the roll.
Ayes 4, noes 10.
Okay, the bill fails to report. Mr. Chairman, do you have an additional bill?
I do.
Senator McClellan, did you have something?
Mr. Chair, I was going to suggest an amendment that at least would address part of the issue with this bill before we move off. And that is because in some of these code provisions, it currently does not say you could prosecute where it was received or where it was sent. And I think at a minimum, we want to do that. So I think if we just strike "or in the city of Richmond" from each of the provisions, that at least would allow for some of these crimes that you could prosecute either where it was sent or received, which currently you can't do. No, not everywhere. If you look, for example.
Do you want to, do I have a motion to reconsider the bill?
Well, it failed to report, but I think it's still before us, isn't it?
Yeah, it's still before us. Whoever voted on prevailing side can move to reconsider.
It needs to be reconsidered. The motion failed to
Okay,
report.
well, I'm not on the prevailing side, so.
Anybody want to move to reconsider the bill?
Is there a second on that motion?
Second.
Well, you're not, you didn't, you weren't on the.
No, you're right.
Mr. Chair?
Senator Peterson.
I'll move to reconsider. I'd prefer we carry it over for the year. I disagree with this entire concept.
Did you move to reconsider?
I did not.
Okay.
Yes, somebody did second. Wasn't that what it said?
Second.
On the prevailing side.
Do you have to be on the prevailing side for second?
He voted, did Richard vote? Yeah. That's right. He voted
Mr.
not to
Chairman,
report.
having voted on the,
Okay. Well, I've
today,
got-
I'll also vote to allow
Okay,
reconsider.
well, we've got a
to get
motion and a
this
second to
point out.
reconsider. All in favor of reconsidering, vote aye. Vote nay if you're opposed. Okay, the bill is back before us.
Mr.
and-
Chair.
And
so
Senator McClellan.
I would move the following line amendments. On line 39, after received, strike the remainder of that line through line 43. On line 49, after received, strike "or in the city of Richmond." On line 60, well, I would leave that one because I think if the communication is about a property in the city of Richmond, I think that'd be fair. So if somebody else wants to strike that, that's fine. But on line 68, after received, strike the remainder of that line through line 72. And on line 75, after received, strike the remainder of that line through 79. With those amendments, harassment by computer or threats to the governor could be prosecuted either where the threat was sent or received.
Mr. Chair.
Senator Peterson.
Let me, and I appreciate Senator McClellan doing some surgery on this bill, but I'd be opposed to it anyway, and let me tell you why.
Well, first off, let me see if there's a second to her motion.
Second.
Okay, so now Senator Peterson, I apologize.
Well, okay. Here's my problem, and that is, this is a statute which deals generally with threats of death and bodily injury to people. And we have, on certain decisions, and I think I voted against some of these, made it applicable to school employees and hospital employees and people like that for enhanced penalties. This is the first time we're adding ourselves to this statute because apparently we're very important people. I don't think we are that important people. And I think to the extent we name ourselves in this statute, of course, we're leaving out other very important people that, quite frankly, may deserve this more than we do. And I have a problem with this body putting ourselves in the code that threats against us are somehow more important than threats against, the local business owner or mayor or somebody like that. We're not special people.
Senator Peterson, let me ask you this. Didn't Senator McClellan's amendment take us out?
Yes.
No. Well, then what's the point of the bill?
Mr. Chair, with my amendments, then threats to the governor, which is currently a crime, could be prosecuted either where the threat is sent or where it is received. So it doesn't add a new crime, it just says venue can be either where the threat was sent or received. And threats, and let me finish, harassment by computer could be prosecuted either where the harassment or the threat was received or made. The problem is you will not always be able to determine where the threat was made, but as has already come out, you should be able to determine where it was received.
Okay.
But isn't that the law already?
That's the law. Mr. Chair, the title of this bill is Threats and Harassment of Certain Officials and Property, and it really only talks about members of the state officials. So I don't understand. I understand Senator McClellan's amendment, but basically we're just gutting the whole bill and putting it back to what I thought what the law was anyway. I just don't think, I don't think this is a
The amendments before the committee, all in favor of her amendments, vote aye. Aye.
Aye.
Opposed? No. Okay, we're gonna have to call the roll electronically on that. All in favor of her amendments, vote aye, vote yes on the machine. Okay, the amendments. The amendment is rejected. The bill, as it was introduced, is before you. Is there a motion, Senator Peterson?
Move to PBI.
I'm going to go by for the day.
I would remind the body, this is a venue bill, period. That's all it is. Can't be prosecuted twice.
So the motion is to pass by indefinitely. Okay, is there a second to that motion? Okay, there's a motion and a second. All in favor of passing by indefinitely, vote yes on the electronic voting machine.
Ayes 9, noes 5.
Okay, the bill is passed by. Senator Edwards, you've got another bill.
I do. Fortunately, only one more. And that is Senate Bill 546. This would increase from 14 years of age to 16 years of age, the minimum age at which a juvenile can be tried as an adult in circuit court for a felony. I understand the Commonwealth's attorneys have an amendment. Yeah, but first of all, let me, I have some people to speak to the bill. I'm sorry.
Mr. Chair, committee members, Amy Woolard with Legal Aid Justice Center. I haven't seen an amendment. We're supporting the underlying bill. I know this would be a significant change, but we really need to get back to the science on this. We have a whole litany of cases, Roper, Graham, Miller, Montgomery, that say kids are not de facto incorrigible just by virtue of what they've done. We should have that consideration on the front end as well. I realize an age raise would be a significant change. Perhaps, in lieu of that, I think any kid who is transferred, 14, 15, 16, 17, should have a judicial hearing and should have full consideration of all those individual factors.
And 16 was the age before it was changed, when we were dealing with the bell curve back in about 95 or 96, is that right?
Mr. Chairman, that is correct. I mean, we swung pretty far back in the early 90s.
How many kids a year between ages 14 and 15 get transferred?
I don't have the specific numbers in front of me. I don't know if someone from the Department of Juvenile Justice is here. I do know that 14 and 15-year-olds, very low numbers of them at this point. And so, I think it's time that we move towards the science and away from that mythology of the 90s.
Okay, thank you. Yes, sir.
Good afternoon, good morning, Mr. Chairman. Nathan Green, Council Attorney for City of Williamsburg, James City County, speaking on behalf of Virginia Association of Commonwealth Attorneys. We came to Senator Edwards, or through his legislative aides, the request that the Commonwealth Attorneys made was that in Section A of the transfer section, that in the original bill would also go up from 14 to 16. We asked that that number stay the same, that in A, it remain 14, which would allow for the court to have a hearing on individuals 14 and 15 on very serious crimes. And if during that hearing, the court heard evidence and was convinced that this was an individual that would be appropriately transferred at 14 and 15, the court may transfer that individual. We have no objection to upping the age to 16 in sections B and C, which are the automatic certifications. But we are asking that at 14 and 15, we are allowed to at least have the transfer hearing. Our primary concern is that individuals who at 14 and 15 commit the most heinous of crimes, if they are not able to be transferred, our ability to supervise those individuals ends absolute at 21. And so there's no more probation. If there's an individual who murders someone and at 21, we wouldn't even be allowed, we would not have any protections from that individual contacting the victim's family.
Mr. Green, how many kids, 14 and 15, are prosecuted as adults every year?
I don't have those numbers. And again, the Commonwealth, as we discussed this bill, the association was very clear. We do not have an appetite for going after 14 and 15-year-olds and putting them in prison. But when a 14 and 50-year-old commits a crime, we are looking to have at least some supervision after the age of 21. Again, we are receptive, and we would support giving up the automatic transfer for 14 and 15, but we want to have the possibility still within A. And so we're just, our requested amendment was to strike to take out the change from 14 to 16 in subsection A, leaving that at 14, moving it to 16 for the automatic transfers on the others.
Okay, thank you. Is there someone else who wants to be heard?
Good evening, committee members. My name is Candace Lucas, and I'm with Advocates for Equity in Schools. We are in favor of this bill. We're actually in favor of the bill going to 21. If we consider the cognitive development as well as the issues regarding a child's ability to ration and accept responsibility and be trained properly, then we understand that 14 is definitely not the age. 16 is definitely not the age. We don't even let our children sign contracts until they're 18. We don't even let them drink until they're 21. So why would we prosecute them and hold them fully accountable at 14 and 16? The prosecution of our children of these ages disproportionately impacts children of color, specifically Black males, as well as individuals that have disabilities. So when we give them, the prosecutors, the option of prosecuting our kids, we're basically giving them the option to throw them away, and we're not rehabilitating them. I worked at Beaumont Juvenile facility as a GED instructor. I had an 11 and a 14-year-old who had juvenile life plus some. Both of those children were under my watch. And if we had done something different as a society, they would not have been incarcerated to begin with. So we definitely need to review this bill and consider cognitive abilities of our children, specifically when we criminalize children of color, because we adultify them. Thank you.
Are there others? Mr. Green, where would your amendment be?
Did you put it right in?
I think your aides did.
Kristen, do you have it? Charles?
Mr. Chair, I believe the amendment is on line 510, which would change it back from 16 to 14. But with this one change, the bill would change, I don't want to say dramatically, but to make this one change, a lot of the sections would have to be taken out, because a lot of the other sections of the bill deal with confinement of juveniles, and we're raising that to 16. But since we're still allowing for transfer hearings, those sections would need to be taken out, because it's possible you could have a 14 or 15-year-old still confined as a juvenile because these transfer hearings are occurring.
Is there anyone who wants to offer Mr. Green's amendment?
And Mr. Chairman, I apologize if I could ask Mr. Quaglio, if there was, my understanding of leaving it as is and only changing it for the transfer hearings would allow for blended sentences. It would still speak to how those 14 and 15-year-olds are detained or where they would be detained, but it would allow for a blended sentence so that after their 21st birthday, we could keep them on probation.
Mr. Chair, I believe that is correct. I don't want to say that is the only change necessary for the bill, because there are a number of other changes in this bill where everything was raised to 16. Like, for example, there is the adjudication as a juvenile for the firearms disqualifier, which we've raised from 16, which would probably need to go back to 14, because again, if we allow these transfer hearings for 14 and 15-year-olds, they would be adjudicated delinquent for a felony if committed by an adult. So it's not just a simple one amendment, one change in that one amendment. There are subsequent amendments that would need to be done to this bill to make that amendment effective.
I've been advised, we don't talk about the House, but I've been advised there's a substitute that does that in the House. And we can deal with that later, yeah.
There is.
Yeah, okay.
This very concept was addressed in the House, and the change was made so that, again, made it clear that at 14 or 15, the Commonwealth could ask for a hearing, and the judge could determine or could review all the evidence to include both the nature of the offense, the nature of the individual charged with the offense, a number of factors that are all within that subsection A, and then the court may transfer. And that language was done in the House.
I move the amendment. Mr. Chairman, I move the amendment.
Well, I'm not sure staff is really prepared to do the amendment. We
Well,
could do it, you'd be moving in concept.
Concept.
At best. Unless we want to try a concept amendment. Senator
I have a
Morrison.
question for the patron. I agree with your bill. I agree, full stop. Why are we changing, or why would you agree to the amendment offered by Mr. Green respectfully if it seems to change the nature of your bill dramatically?
I don't know if you can count or not, but we have got to go into session at 11 o'clock.
Trying to help you.
I know, thank you.
And
I'd
I-
like to get the bill out. And the House has already agreed to that, apparently.
Okay, the amendment in concept would basically allow for hearings for 14 and 15-year-olds for the most serious offenses. Is that correct?
That's correct,
Mr. Chairman. Mr. Chairman.
Senator Stewart.
I want to make sure I understand it, because this is a pretty significant issue. What the amendment would do is take away the automatic transfer.
Right.
If they are 14, and it puts it in the hands of the judge to make the decision based upon the record and the evidence.
That's right.
I can support that, but I want to make sure that's what we're doing.
Yeah, Mr. Chair, that's correct. And I guess to highlight the point that I'm trying to make with the additional changes that needs to be done to the bill, for example, in the introduced bill, there is the DNA sample that's taken for these adjudications. In the introduced bill, we bump it up to 16, but because we are amending the transfer statute back to 14, the permissive transfer, we would need to amend that section to go back to 14. And that's what I'm trying to say, Mr. Chairman.
So it sounds like when we're talking about amendment and concept, we're really talking about a substitute by the time we get to 14.
That's right.
That's correct, Mr. Chair.
Okay. Does everybody understand what the amendment and concept would do? Do I have a motion on the amendment and concept?
So move.
Okay. All in favor of the amendment, say aye.
Aye.
Opposed? No. Okay.
Move to report. I move the bill, the substitute be reported.
Substitute be reported.
Mr. Chairman.
Senator McDougal.
Before we do that, Senator Edwards, I heard you say that you want to get this out. Are you going to be okay sticking to this line of amendments? Because I think some of us have a real concern that the bill as originally introduced would allow a person that committed murder at the age of 15 to then be finished with any sort of penalties at the age of 21.
I'm a realist, and I would like to get the bill out, and we'll see what happens. But
Mr. Chairman, we'll see what happens.
Senator McDougal.
Makes me concerned. I'm asking Senator Edwards, is he going to try to revert this back to the current version that would allow a 15-year-old murderer to end all process with the government at age 21?
I'm not sure that would pass. I'd like to get something out. I think this is the version that's probably going to pass.
Mr. Chair, have we already amended it?
Yes, we have.
Then I have a motion to report as amended.
Okay. We already got that motion pending. Senator Morrissey has seconded it. All in favor of supporting the substitute, or reporting the substitute as a substitute, vote aye on the electronic voting machine.
Ayes 9, noes 4.
Okay, the bill is reported. Senator Edwards, do you have another bill?
No, I think I'm finished. Done for.
I'm next. Okay, I'm next. The first bill I've got is Senate Bill 282. Several years ago, we made mandatory the ignition interlock for first offense of DUI. The ignition interlock is an expensive process but it's designed to determine whether the person that's driving has any alcohol in their system. And you could argue that it's been an effective deterrent for those who wish to drive under the influence who get into the car and have alcohol in their system, won't let the car start. This was brought to me by a lawyer in the area I represent who has represented a bunch of people that are DUI drugs. And the breathalyzer does not, the ignition interlock doesn't pick up the drugs. And it's kind of an expensive proposition for people who have been convicted of DUID, and it's the deterrent's not really connected to the crime they've been convicted of. So this offense would make it would allow a judge to order the ignition interlock, but not require it for DUID. You put that bill in?
Well, this is this year. Let's get through today.
So that's the bill. Are there those that would like to speak in favor of the bill? Are there those who would like to speak against the bill?
Move the report.
Okay, all in favor, vote yes on the electronic voting machine.
Ayes 14, noes 0.
Okay, the next bill I've got is 286, which is the same as Senator Stanley's 309, that basically it's the one I was talking about earlier that is broader than Senator Stewart's bill, but narrower than yours, right. It allows for deferred dispositions in certain cases. Senator,
I moved to incorporate somebody's into someone's.
okay. Well,
No, those two.
I've got 206, Stanley's got 309, I think.
I move that we roll 309 into 286.
Okay, that means that I think I rolled my bill the last time into your bill, so you can do that? That's all right? Okay. All in favor of a substitute with 309 into 286, vote yes on the electronic voting machine.
To incorporate.
To incorporate. Okay, the bill is relatively simple. It's not as broad as Senator Survell's bill, which passed out of this committee a couple weeks ago. It's broader than Senator Stewart's bill that reported out earlier. Mr. Green, you've got some comments? You're okay?
Your Honor, excuse me, Mr. Chairman, Nathan Green, once again, for speaking on behalf of Virginia Association of Commonwealth Attorneys. This represents the work of VCJC and compromises that came from both prosecutors, defense attorneys, and judges, and we think this is a good bill.
Okay. Okay, a motion and a second to report any further discussion. All in favor, vote yes on the electronic voting machine.
Ayes 14, noes 0.
Okay. Mr. Chair, the next bill I've got is Senate Bill 325. 325 codifies some of what happens in voir dire in that you ask in a criminal case, you ask potential jurors questions that relate to their ability to render an impartial verdict, but it allows you to inform the jurors of the range of potential punishments. That's new. And I would suggest that that's somewhat of a hole in the criminal law, right? An existing law right now, that jurors need that information in order to render a fair verdict. and they need it going in, because very often, they'll find guilt or innocence, they'll find guilt, and then they realize for the first time, at the bifurcated stage of the trial, they realize for the first time, well, there's a minimum mandatory 5 years or 3 years on that offense, or 2 years, or it's even 6 months.
Or 20 years.
Or 20 years, but you can't do it on other than capital murder cases. There's a Supreme Court case, I think. Well, that's what this bill's about.
Move to report.
Are there those in the audience that would like to speak about it?
I'm shocked to hear this. Ms. Sachs?
Second.
Been moved and seconded to report the bill. All in favor, vote aye. All opposed, vote no.
Ayes 13, no 0.
Okay, thank you.
13-0.
Do I have another bill?
Yep.
618, okay. I've got Senate Bill 618, which deals with the larger specialty docket matter, which we dealt with Senator Morrissey's bill last week. 618, I think, is a bill that was requested by a general district court judge in Augusta County, and it seems to me that this bill is probably not ready for prime time, so I would ask that you carry this bill over.
I believe this is the bill that I received from the General District Court judge in Roanoke and said it's already being done, I believe. I think it's the bill.
Yeah, I've already moved to carry it over.
Okay, is it moved and seconded to carry over the bill for the year? All in favor of the motion, say aye. Vote aye. All opposed, vote no.
Ayes 14, no 0.
14-0. Okay, Senator Morrissey, how many more bills do you have? Can we do them quickly? Go ahead, Senate Bill 798.
Mr. Chairman, I noticed that when I said I'll do it quickly, that Senator Norman was smiling broadly. Bill 798?
Yes, Senate Bill 798. Driving after forfeiture of license.
Mr. Chair, maybe since I can face folks, I can do it better here. This bill we actually touched on a few moments ago. This bill says that a person is guilty of an offense of driving or operating a motor vehicle after his driver's license has been revoked only if such person is driving a motor vehicle on a highway. Right now, you could be found guilty of driving a automobile or a vehicle after having your license suspended if you're driving your lawnmower tractor on your lawn, if you're driving your golf cart on your own property, if you're driving a forklift at your job.
Or, Mr. Chair, if you're driving it, doing wheelies on the Walmart parking lot.
Correct.
All right, go ahead. Where are we?
On Senate Bill 798.
All right, 798.
Mr. Chairman.
Go ahead, Senator Sherrill.
Yeah, we passed this bill in 2016 and 2017, although the Senate Courts Committee did not report it in 2018. To me, it was my bill.
Okay.
It's a pretty simple
All right,
bill.
is there a motion to report?
Mr. Chairman?
Yes, Senator, who?
Down here.
McDougal.
So it's three different things. So the first one is if you drive without a license. The second one is if you have a BAC above a .02. And the third one is if you have ignition interlock. Is that accurate?
Correct.
Okay.
Mr. Chairman,
Yes,
so.
Senator McDougal.
So is a lawnmower considered a motor vehicle?
Yes. And so is a bulldozer and a tractor and a forklift and moped, right.
Okay.
All this says is that you have to be operating on a highway.
On a highway, all
Well,
right.
you know, and I would just, Mr. Chair, if I could, I would just say, to me, it's different than if you're sitting in your driveway listening to a ball game, or if you're on a, say, on a Walmart parking lot where there are other people that could be jeopardized by your.
But if you're listening to that ball game in your driveway and the keys are in the ignition,
Yeah.
you are guilty of this offense.
But not under the bill we just passed a little bit ago. Under this bill, you wouldn't be guilty on that Walmart parking lot either.
Under this, Mr. Chairman,
Senator Sir.
under this bill, if Stewart's passes, under this bill, you could still be prosecuted for a Class 1 misdemeanor after DUI, sitting in your car, listening to a radio game in your driveway, under this bill. Unless this bill passes.
Mr. Chairman.
Yeah, Senator McDougal.
So, but, Mr. Chairman, I think what Senator Deeds trying to ask, so if you drive and you have a .07 BAC and you're sitting in the Walmart parking lot and you don't have ignition interlock on your car after you've been ordered to get an ignition interlock, the government finds you in the Walmart parking lot, didn't see you on the highway, they cannot convict you.
Mr. Chairman, I don't think that's correct. I'm looking at the definition of highway. Highway is the entire width between the boundary lines of every way or place open to the use of the public. So any place open to the use of the public, that would include a parking lot, for purposes of vehicular travel.
Okay. Is there any further discussion? Is there a motion?
Well, Mr. Chairman.
Senator McDougal.
Doesn't that definition say specifically designated highways by an ordinance adopted by the governing body? And the second part saying owned or leased by the United States government? I don't think of that definition includes private parking lots.
Mr. Chairman.
Senator Sherwood.
Thank you. I believe under 462100, public highway means anything that's open to the public. And a lot of parking lots typically do not qualify because they have a restriction. They say you can only use the parking lot for purposes of visiting the store, you know. However, I believe, anyway, so most parking lots don't count as highways because they have that no trespassing sign in them, okay? But what this bill seeks to do, right now, to be convicted of driving on a suspended license, it has to be on a highway. But for driving on revoked, it says anywhere on the planet, including your yard or where you work or whatever. And this just seeks to make the two identical.
Senator
Chairman,
McDougal.
If you've been convicted of a DUI and you do not have ignition interlock on your vehicle and you are stopped in the parking lot of a box store, Walmart, wherever, and nobody saw you come into that parking lot, then you are not guilty.
Of driving on revoked.
Of driving on revoked. And that's.
I'm not so sure about that.
Mr. Chairman, the reason there's some disagreement between the two corners of the panel is that some judges, both in courts of record and general district court, and they have differing opinions on what that Walmart parking lot is.
I think you're right.
And what's happening right now is Senator McDougal, as is his right, is focused on the parking lot at Walmart. Others are focused on the really silliness of saying that you're in your car, in your home, listening to the radio, or you're driving a golf cart on your own property, or if you're even on your job working and driving a forklift. And it also brings consistency to the language regarding driving on a suspended license on a highway versus non-highway.
Thank you, Mr. Chairman. Mr. Chairman, I think to Senator McDougal's point, I believe that a Walmart parking lot would fall within the definition of 46.2-100, clearly. However, even if it didn't, I think 46.2-100 also says any way by resolution of the city, county, or town. So if for some, or it used to. So even if it didn't qualify under 46.2100. Blanketly, the county could always say, we adopt a resolution to include that within a defined way as a highway. And I think that solves the problem.
That's correct, Mr. Chairman.
Okay, we got to move along. We got 12 more bills in 40 minutes.
Mr. Chair, I move to report.
Is there a second? All in favor of the motion to report the bill, vote aye. All opposed, no.
Ayes 11, noes 3.
11 to 3, the bill is reported. Senator Morrissey, you got some others. Can we go?
Senate Bill 801, Mr. Chairman.
801, Senate Bill 801.
This bill provides that in any criminal case, a subpoena ducis tecum may be issued by an attorney. Two other points. It shall be on a form that's approved by the Executive Secretary of the Supreme Court. And 3, it shall apply mutatis mutandi, which means same thing, same application as done in the General District Court. Right now, a subpoena for a witness can be done by an attorney. It's called an attorney-issued subpoena. This allows the subpoena ducis tecum for documents to be done by the attorney.
Okay.
The last thing I'll say is it also mirrors the procedures held in civil cases under 16.1-89.
This makes the criminal procedure the same as the civil procedure.
Yes, sir.
In terms of issuing subpoenas by attorney. Okay, any speakers in favor or against? There we go. Somebody's in favor?
Against, Mr. Chairman.
Against,
Mike
okay.
Doucette, Commonwealth, who used to be Commonwealth Attorney, Executive Director of the Commonwealth Attorneys Association. What this bill, I'm trying to figure out what this bill does. I mean, if it requires, under existing law, you got to basically send a request to the court to issue a subpoena. This is going to be the attorney's going to fill out the subpoena and send it to the court, which is, it's not going to save them any work. What it does do, after figuring out, what it does do is it eliminates the notice to the adverse party and an affidavit that says that the requested writings are material to the proceedings, are in the possession of a person not a party to the action. So what this will do, for instance,
Mr. Chairman?
Yeah, Senator.
A question for
Chief Peterson.
Surville. Isn't it true that Commonwealth attorneys can issue subpoenas right now without the approval of the court?
we can do subpoenas. We can't do subpoenas ducis tecum.
Okay, but
We cannot do subpoenas ducis tecum.
Okay.
We have to go through the court.
This would allow you all to do a subpoena ducis tecum, right?
Without notice to the adverse party. And what this does,
Mr. Chairman,
for instance,
further question.
Would you let him finish the question, the answer?
what this will do, if you look at a case like Farish versus Commonwealth from 2 Virginia appeals, where there was a fishing expedition for the psychiatric records of a rape victim. And when we moved to quash that particular subpoena ducis tecum, and the defense reply was, we don't know what was in there. We just wanted to see if there was something in there. This would allow that fishing expedition into psychiatric records.
Mr. Chairman. Senator Peterson, Peterson.
Don't you have that in civil cases all the time? I mean, if it wasn't for motion to quash, I wouldn't be in court every Friday.
Mr. Chairman, I've never practiced.
That's what we do.
Mr. Chairman, I've never practiced civil law.
But Mr. Chairman,
Senator Owenshine.
the difference between, I heard Senator Morrissey say this is exactly like the civil system. It is not, if it does not require notice to the opposing party. The reason Senator Peterson's in court on Fridays is because his opposing party is filing motions to quash left and right about his fishing expeditions.
Senator Morrissey, can you put a minute to
Yes,
give
there
notice?
seems to be a flavor for that, and I have no objection at
Chairman.
all. I might suggest to staff that on line 17, after pleading and noticed, provided to the Commonwealth's attorney.
Mr. Chairman.
Okay, is there a move?
Can I ask my question I
Just a
tried to
minute.
ask?
Let's stop a minute. Do you have a question on the amendment?
Yes, I do. I
Okay,
was trying to
what's
ask
the
you, you cut
question?
me off. The rules of court require any pleading to be noticed to the other side. So, I mean, I'm not clear why we need to state in the law something that's already in the rules, because we don't state for every pleading or motion that has to be filed, you have to give notice to the other side, because that's what the rules are.
Is that?
Mr. Chairman.
Yeah, Senator Steve Benjamin.
Currently, Rule 3A12 requires that a motion for a subpoena ducis tecum be sent to the adverse party. And so I would suggest similar language after the words mailed or delivered to, insert the adverse party. and the clerk's office.
Okay, is that the motion?
What line is that, Steph?
I think that's line 18.
Okay, line 18. You have the motion as is reported by the distinguished counsel, Steve Benjamin. It's been seconded?
Second.
The motion is made and seconded to adopt that motion. All in favor of the motion, say aye.
Aye.
All opposed, no. All right, any other discussion?
Also, Mr. Chairman,
Yeah.
and I think this is consistent with Senator Morrissey's bill, on line 13, it says notwithstanding rules 3A12, part of 3A12 prohibits a subpoena ducis tecum to a member of the bar without leave of court, and I don't think that the patron intends to change that provision.
That's correct.
And so it should be 3A12B, which is the subsection dealing with subpoena ducis tecums.
Okay, notwithstanding rules 3A:12B and 7A:12.
Just 12. Yes.
Okay, is that right? All right, it's been moved and seconded that amendment be adopted. All in favor say aye. Aye. All
Aye.
opposed, no. Motion carries. Any further discussion? You got somebody behind you.
Mr. Chairman, Keenan Hook with the State Police. Our concern is just that this bill would appear to extend the subpoena ducis tecum to parties to the action. Under Ramirez versus Commonwealth, the law enforcement agency that is involved in the investigation and prosecution of the offense is a party to the action for purposes of discovery. And so what we feel like this would allow to happen is the subpoena ducis tecum to be issued to, in this case, the state police, rather than going through the traditional discovery process.
Mr. Chairman?
Yes, Senator Oberchain.
You know, medical records. Mike mentioned going fishing for psychiatric records. You know, and I don't practice criminal law, so I don't know how this exactly works, but if in the civil system, if you issue a subpoena for medical records, the healthcare provider is expressly prohibited by 801-413 from producing those records until 15 days have passed and they receive certification that there has been no motion to quash filed. That's in order to prevent those kinds of fishing expeditions, and I don't know whether 801-413 would apply to this criminal process, but I would be very concerned if it did not.
It does, Mr. Chairman. In the criminal arena, we have to comply with the HIPAA.
HIPAA. It's federal law. HIPAA is federal. Okay. Any further discussion? Is there a motion? Yes, Senator Stewart.
A question for the patron. Does this subpoena ducis tecum even is there any restricting language? Because I don't see it. And what I mean by that is, does it even have to be relevant to the defendant's defense? Or can they just file a subpoena ducis tecum seeking any information?
Well, I would say this, if it was just a fishing expedition or it had no, I'll strike that, if it had nothing to do with the case in chief and it was done to create mischief, for lack of a more artful or legal word, I think that attorney could be sanctioned. Remember, this can only be done by an attorney who's an active member of the Virginia State Bar.
Okay. All right, any further discussion? Is there a motion? Motion is made to report as amended. Is there a second? Second. All in favor of the motion to report as amended, vote aye. All opposed, vote no.
Ayes 8, no 6.
Ayes 8, no 6. The motion is, the bill is reported as amended. All right, you got 2 or 3 others, I believe.
I do. I'll go quickly. The other one may generate some conversation. It's the Senate Bill 802, the death penalty moratorium. Let me just start out by saying what this, we all understand the nature of a moratorium. Let me say what this bill does not do. It does not affect any matter related to death penalty, including bringing a capital charge, sentencing proceedings, imposition of the death penalty, appeals, etc. What it does is it establishes a moratorium on the death penalty. With that said, I think I said the other day that 21 states have abolished the death penalty. Virginia is number 2 in executions out of 113. There have been, since 1976, and this is the point that I want to leave with everybody. I hope respectfully you would leave this room remembering this statistic. Since 1976, 166 people have been exonerated in the U.S. after being sentenced and they're on death row. And at the same time, 1,510 people have been executed. So once again, 166 people that were sentenced to death were exonerated. 1,510 have been executed. So a little bit more than 10% were pulled off death row because they were innocent. And the Commonwealth Attorney, the prosecutor, agreed that that was the case.
Senator Morsi, it's almost 10 o'clock. It's going to take a long time to go through this. We might have nobody is on death row right now, I believe. It's imminent. Is that right? 2 people on death row.
2 people. We haven't had any executions in 19 or 18. We've had 8 executions in the Commonwealth since 2010.
Yeah.
It's a moratorium until we study this issue. I
understand. Is there a motion?
Mr. Chairman, I move.
Review the time.
Carry the bill over for the year.
Been moved and seconded to carry the bill over for the year. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 4.
Okay, thank you very much.
Mr. Chairman.
I want to take the liberty of getting Senator Serval out of here. He's got a bill 433, and then we'll go back to you. He's got to be someplace else.
Thank you, Mr. Chairman. This is a bill I think you all are very familiar with. It basically decriminalizes adultery. It's supported by the Family Law Coalition. I've explained it repeatedly before. This is just so that people will not be able to take the Fifth Amendment in divorce cases anymore. This causes a huge amount of wasted time, effort, and energy in divorce cases.
Mr. Chair, Senator, I have an amendment which would basically repeal that provision of the code that you showed me that says you cannot, that in a civil case, a person exercising the Fifth Amendment rights cannot be
take an adverse inference.
Yeah, it is. You cannot take the adverse inference. It would be like the federal system, which is in a civil case. If you raise the Fifth Amendment, the trier of fact can take the adverse inference, but so that the person can still exercise their Fifth Amendment rights against self-incrimination. But the adverse inference can be drawn by the trier of fact. In Virginia, that's not the law. This would change that.
I need it.
And that's my motion. So we keep the adultery as a criminal offense, a misdemeanor, but the adverse instance could be drawn. Is there a second?
I'll second that.
Is there any discussion to the motion? Okay, a motion to amend is before you. All in favor of the motion, say aye. Aye. All opposed, no. Well, the motion carries. All right, is there a motion on the bill? Any discussion?
Move report.
Second. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 8, noes 5.
Ayes 8, noes 5. Okay. And the bill passes, substitute passes 8-5. All right, Senator Serval, you're free to go to your next meeting. Okay, Senator Morsi.
Thank you, Mr. Chairman. 2 more bills. The first one is Senate Bill 807. Senate Bill 807 eliminates the enhanced Class 6 felony. If you look at lines 19 and 20, it just prohibits the individual who was convicted of a third offense of petty larceny to be sentenced to a Class 6 felony. The genesis of this bill was the following headline in the Richmond Times-Dispatch that I cut out. Woman died in prison after stealing $45 worth of goods. So I looked into it a little bit more carefully, and she did have a record. She had some mental health issues of stealing. On this particular occasion, her attorney came to court and said, listen, I've got the solution. I've got her into a program. It was George's Healing House in Charlottesville. That program would have addressed she had some mental health issues. Notwithstanding that, the judge did not put her into that program. She was sentenced to 5 years with 2 years suspended, so she got a net sentence of 3 years. One of the things that struck me is that we are incarcerating that person, if you count capital cost, to the tune of $42,000 a year. So the Commonwealth is locking somebody up for $126,000 to our taxpayers for stealing $46 worth of goods.
This is the 3 strikes and you're out.
Yes, sir.
Kind of bill, okay.
There are 164 offenders who are in prison right now solely under that law that can turn a third petty larceny conviction into a felony punishable up to 5 years behind bars.
Okay, any people voting, speaking in favor of the bill? Anybody speak against the bill? Okay, we got to Hanover behind you.
Somebody behind you. I beg your pardon.
Mark Siegel again, Mr. Chairman. Currently, if the previous convictions were for robbery, because it's any type of larcenies that are in there or similar offenses, a robbery and a grand larceny that resulted as a separate, totally separate offense from the robbery from, for instance, a burglary. And then the third arrest was for a $499, just under the threshold, then it would always be a misdemeanor. And there's no mandatory minimum for a third offense, but there currently is in the state statute a mandatory minimum of 30 days with a maximum of 12 months for a second offense. There actually is a VCC code for sentencing on second offense charges. So third offense doesn't add anything additional, even if it were to become a misdemeanor. Perhaps the threshold for a misdemeanor, if it was just misdemeanor larcenies to protect citizens, particularly store owners or family members that have people stealing from them, if it was that it was a fourth or fifth conviction of just a misdemeanor, but not a combination of other felony larceny types that are in there. And those are our objections.
Okay, thank you. The judge has sentencing guidelines now. And this 3 strikes, you're out, in effect, has come under disfavor, I believe. Anyway, anybody else in favor of the bill or against the bill? There's a motion. Senator Morrissey moves to report the bill. Is there a second? I second it. All in favor of the bill, vote aye. Aye. All opposed, no.
I 6 no 7.
6 to 7, the bill is not reported. Okay.
Mr. Chairman, the last bill is SB 810. This involves sentencing guidelines. This bill requires that the jury be given the applicable discretionary sentencing guideline worksheets, but with the caveat that the judge tell the jury that the guideline worksheets are discretionary and not binding on the jury. We've had many discussions in this panel and this committee regarding truth in sentencing and getting the most information. Particularly Senator McDougal has been very, I say that respectfully, very much an advocate of that position. That's what this bill does, get those sentencing guidelines to the jury.
Anybody in favor of the bill? Any questions of the wit of the patron? Anybody against the bill? Is there a motion? Is there a motion?
Mr. Chair, I'm all in favor of giving the juries more information, but I'm afraid if they have the guidelines, you overload them with information. That's my concern with this.
With regard to that inquiry, Mr. Chairman, right now juries are given instructions. They may go back there with 28 instructions on the charges. That's not an exaggeration. But what this is another document that we all rely on. The judges rely on it, the prosecutors, the defense attorneys. And it is also a guideline that's reflective of what Crime Commission wants. It's one other additional document. Is it more information? It is. Is it relevant information? It is.
Is this at a bifurcated trial?
Yes.
Okay.
And Mr. Chairman, the
Senator
only information
Steve.
that it adds is, and this is important information, is the sentencing guideline range, the recommended historical range, the minimum, the low point, the high point, the midpoint.
Okay, all right. Anybody would like to move, Senator Morrissey moves the bill be passed, reported. I will second it. Any discussion? All in favor of the motion, vote aye.
It's a terrible idea.
That's why it's so good.
It says it's been given to Morrissey. I think he was supposed to give it to me, but.
Okay, let me do that.
Ayes 806.
8-6, the bill is reported. Senator Norman, you're finished, right, Joe?
I am, Mr. Chairman.
Okay. Senator Norman, you have Senate Bill 1071.
Thank you very much, Mr. Chairman. If it's all right, I'll do it from here. It's pretty straightforward. As you're aware, there are some significant backlogs that are in the Department of Forensic Science, and that is not a criticism. That's because we're making so many demands on them. What this bill would do is it would allow post-conviction DNA testing by credentialed labs other than the Department of Forensic Science. There has been some language, I think, in the form of amendment that's come from the Department of Forensic Science, and you would report that.
Okay, is there a motion to?
I'd move the adoption of the amendment from
substitute?
DFS.
Motion been made and seconded to adopt the substitute. All in favor say aye. Aye. All opposed, no. Motion carried. Is there?
Amendment.
Oh, amendment, okay. All right. Yeah.
I think.
Yeah, read the amendment, if it's short.
Mr. Chair, the amendment is basically striking after the word by the remainder of lines 58 and all of lines 59 through 62, and inserting an accredited body that requires conformance to forensic-specific requirements, that is a signatory to the International Laboratory Accreditation Cooperation Mutual Recognition Arrangement with a scope of accreditation that covers the testing being performed and follows the appropriate quality assurance standards issued by the Federal Bureau of Investigation.
Okay. Is it been moved and seconded, the amendment be adopted. All in favor say aye. Aye. All opposed, no. Motion carries. Is there somebody who wants to speak for the bill?
Thank you, Mr. Chair and committee members. My name's Jenny Givens. I'm a director at the Innocence Project at the UVA School of Law, and I'm here just to express our support and to indicate this bill is really necessary to create, to fix a gap that was created by 2018 decision from the Virginia Supreme Court. Currently, folks who cannot get DNA testing conducted by the Division of Forensic Science because DFS doesn't have the technology are not eligible to seek a writ of actual innocence. And so this is just designed to let everyone have access to this writ, including folks whose evidence is really old and degraded and for whom DFS cannot conduct testing. Oftentimes, it's necessary to send this material out to private labs who employ techniques that DFS just simply doesn't have access to at this point.
Okay. Mr. Chairman, I didn't get into the depth of it, but there's some new emerging technology that DFS does not have, and the only discussion was the actual amount of credentialing that these labs would have, and what's before you has been signed off.
Okay. Is there a motion to report? Moved and seconded to report the bill as amended. All in favor vote aye. All opposed, no.
Thank you, gentlemen.
Ayes 12, no zero.
Ayes 12, no zero. The bill is reported. All right, Senator Stanley, you're the last person on the list. And where's Stanley? Here he is. You have six 5 bills, holy cow.
You know,
And
it's
it's
now
now 10:13.
I sat here and watched yet another time where Joe Morrissey messes up my scheduling in my day. So, and that's from friendships for 30 years doing that. So, Mr. Chairman, I'll run through this as quickly as possible. Senate Bill 307 is good conduct for juvenile offenses, which allows for basically good time every juvenile who's sentenced. The rate of 1 day for each day served, including all days served confined in jail, security detention, prior to conviction, and sentencing, which person has not violated the written rules and regulations. So basically, this is an amendment to yesterday's children, that for those defendants who have turned 18 and been sentenced up to 12 months in jail will earn good time credit at the misdemeanor rate of a day for a day and include time served in juvenile detention. That's the bill.
Okay, is there any discussion? All in favor of the motion to report, it's been moved and seconded by Senator Stanley to report. All in favor of the bill being reported, vote aye. All opposed, no.
Can you hit me? Thanks, Tommy. I'm a yes. Can you hit me? Yes.
What are you, yes or no?
Right now, I'm turning into a no very quickly.
Ayes 10, noes 2.
10 to 2.
Obenchain and who
bill
else?
is reported. All right, Senators 309.
Senate Bill 309 is with regard to larceny and stolen goods. It actually provides a.
We've already done 309.
Oh, yeah, that's right, incorporated. Next. 312.
309 is would you say I'm sorry, incorporated into.
Right.
206. 286. Okay, I got you. All right, Senate Bill 312.
312 comes as a recommendation of the Judicial Council of Virginia. This bill clarifies that sex offenders are convicted of knowingly failing to register or re-register with sex offender crimes against minor registry is required under law, are subject to both a period of suspended post-release incarceration and post-release supervision.
Okay.
Why do we need this? I mean, basically, the statute that we have does not have the benefit of case law, which makes clear that the judges are required to order both post-release incarceration and post-release supervision at the time of sentencing. And nor does it benefit from the cross-references of 18.2-10 and 295.2, which allows up to the two statutes to operate in conjunction. So this is clearing something up based on some court cases, Eggleston versus Commonwealth and Wright versus Commonwealth, decided in 2017.
Okay.
That's the recommendation of the Judicial Council.
It is. This is from the Supreme Court.
Okay, it's been moved and seconded the bill be reported. All in favor, vote aye. All opposed, vote no.
I mean, you didn't think I thought that up myself, did you?
No, not really.
Oh, wow.
Okay. Did you got it? Senator Deeds didn't.
I apologize.
We'll put down a yes for Senator
Yeah,
Deeds.
for Deeds, Lucas, and McClellan.
Do we need to reconsider this, or, all right. Deeds, Lucas, so the vote is what?
I've got Senator Deeds, Lucas, McClellan voting yes.
So the vote is 13-0. The bill is reported. Senate Bill 771, Senator Stanley.
Thank you, Mr. Chairman, members of the committee. 771 is to allow an interlocutory appeal on certain occasions. If you'll see them on lines 36 through 46. When prior to the commencement of trial, circuit courts entered any pending civil action, an order granting or denying a plea of immunity that if granted would have immunized the movant from compulsory participation in the proceeding, that order is eligible for an immediate appellate review. Within 15 days of the entry of the order, that the aggrieved party can file a petition for review with appropriate appellate court in accordance with the procedure set forth generally in our civil matters. No petitions or appeals under this section stays the proceeding in circuit court unless the circuit court or the appellate court orders such a stay. And the failure of any party to seek this interlocutory review under the section doesn't preclude that review on appeal from a final order. And there's an amendment.
There's an amendment?
We have two amendments, Mr. Chairman. On line 37, after plea of, insert sovereign, absolute, or qualified. And then on line 41, at the end of the line, after unless, strike, the circuit court or appellate court orders such a stay, and insert, 1, the petitioner appeal could be dispositive of the entire civil action, or 2, there exists good cause other than the pending petition or appeal to stay the proceedings.
And Mr. Chairman, members of the committee, this comes from Boyd Graves and is supported by the VTLA.
Is there, do we have a? in
Hold
writing?
on.
Yeah, see, Christian, do you have a writing? Yeah. Okay, thanks.
Let me ask a question, Mr. Chair. Mr. Chair.
Senator Peterson.
Can someone give me a real-world example? This deals with an immunity where immunity is granted. Can you give me an example of that?
Yeah, well, the case would be in the instance of governmental immunity, for example. Legislative immunity was one example from several years ago.
Sovereign immunity.
Sovereign immunity. Yes,
Okay.
and the amendments limit it to sovereign, absolute, or qualified.
Because we just went through the bill I had earlier on First Amendment cases where I was very careful to not have interlocutory appeal, which obviously could.
Right. This is one where it's, the party is in the case or out of the case as a result of the immunity claim. And this allows it to be subject to an interlocutory appeal to resolve those claims when the initial demurrer, for example, has been
So the person that would assert this interlocutory appeal, would the person be on the receiving end of the immunity claim?
The person protected by the immunity.
No. You got it backwards. In other words, if someone raises sovereign immunity.
Yeah, right now, you can only make a request for an appeal.
If the immunity has been granted.
If the immunity has, yeah, it goes both ways, yes.
Well, hold on a second. That's not what I want to hear. If it goes both ways, then I can't ever get to court. In other words, Mr. Chair, if someone raises an immunity and the court says, nope, sorry, you got to participate in the case, and then they get an automatic interlocutory appeal, then I could get hung up for a year in an appellate court when I have a perfectly valid claim.
Mr. Chairman, Senator Peterson, you're exactly right, and that's why we made VTLA asked for these tweaks from the patron. Is the original intent, as I understand from Boyd Graves, was to have this match what is federal practice. In Fourth Circuit, if you make a plea of immunity, sovereign immunity, and you lose, you can take an interlocutory appeal to the Fourth Circuit.
All right.
And there's no counterpart to that in Virginia right now.
I don't want that. I don't want someone who loses an immunity claim to be able to hang up a case for a year.
Mr. Chairman, Senator Peterson, and I think that that's why we wanted to make it clear that you, with the proposed amendment, is that you can't take that, the interlocutory appeal won't stay the case for years and years unless, one, it's dispositive of everything. So it's one defendant, one claim, and that's going to be the end of the case. Or I'm sorry, if there's multiple claims, you're going to be able to continue. Or two, there's good cause other than dependency of the appeal. Because the concern you have is exactly what we were concerned about as well.
Mark, should I trust you?
Mr. Chairman, Senator Peterson, I would hope so.
Okay, is there a motion? Do we adopt the amendment? Is there a motion to adopt the amendment?
So moved.
Second, all in favor of adopting the amendment, say aye. Aye. All opposed, no. Motion carries. Is there a motion on the bill? It's been moved, and Senator Stanley seconds the motion to report the bill as amended. All in favor, vote aye. All opposed, vote no.
I'm still not sure about
Peterson is abstaining.
I don't trust him.
Senator Peterson, I've known Mark since I was 11, so I don't trust him.
Okay.
I'm with you on that one, buddy.
The bill is reported 13-0. Okay, now we have one more, is that right?
Yes, and Mr. Chairman, members of the committee, Senate Bill 1018. If you do recall that I proposed the bill that now allows for substantial assistance to occur, a post-conviction where a prosecutor uses somebody who's been convicted, perhaps incarcerated, uses information to obtain a conviction on another person. Until that bill, we never had the ability to then reduce or reward the person that helped. We are now like Rule 5, Rule 35 in the federal court. This just adds, because we keep talking about wanting to keep guns out of the hands of those who should not possess them. This adds, with regard to grand larceny of firearms, and regardless of the firearms value, and participation in criminal street gang activity or recruitment of persons in criminal street gangs. So what we're trying to do here is keep the illegal guns off the streets, keep the illegal guns out of the hands of those that participate in gangs, and bust up gangs the best we can.
Okay. Senator Morrissey.
Senator, I like the bill. I just don't understand why you limit it to people charged with the investigation of grand larceny of a firearm or criminal street gang participation or recruitment of people to become street gangs, if there is some information that would be helpful to law enforcement, to wit, so-and-so committed a murder, here's the murder weapon, why do we have that limiting language in there if we want to encourage people to cooperate with law enforcement?
Mr. Chairman, I'd answer the gentleman, but if you see through lines, what we've already put in the code covers some of the most serious and major crimes, including but not limited to murder. So if someone is to provide information, then that's in there. This is just putting a little, and actually I thought about this one during our summer session that didn't come about, which was let's get the firearms out of the hands of those who should not have them. Let's stop the trafficking. This gives an incentive and an opportunity for the Commonwealth, another tool in the toolbox to use, so they can go after those people that are trafficking in firearms who should not be, or engaged in gang activity, which usually accompanies the firearm.
Thank you, Mr. Chairman.
Mr. Chairman,
Steve Benjamin.
if Senator Morrissey wished to move an amendment, then on line 15, after the word "for," you would insert any felony offense and then strike the following language down to line 18 through similar offense.
Would that be a friendly amendment?
No, not right now.
So
It's 10:25. I am not into any friendly amendments right now.
Well, I'm here to
okay?
help
And I
you.
love Joe.
Not showing it.
Look, Mr. Chairman, I think I'll remind everybody that this was hard enough to get through the General Assembly last year, the year before, and this is where we found consensus with Commonwealth attorneys and everybody else, and VTL, defense attorneys, whatever.
This is Federal 35 light.
Yes, light.
Mr. Chairman, I should remind the committee that one of the problems that we've discussed in previous years has been that if the federal authorities want somebody's assistance with a federal investigation, even a very serious federal investigation, then there's no opportunity for relief.
That's right.
Well, Mr. Chairman, I'd say that, or any substantially similar, on line 18, similar offense in any other jurisdiction, I would count that jurisdiction also to be the federal, but maybe he sees it differently.
Okay. You don't think you can get it passed if we just put any felony? Substantial assistance to any felony? All right, is there a motion?
Move to report. Second.
Is there a second? All in favor of the motion to report this good bill, vote aye. All opposed, no.
Morrissey.
Ayes 12, no 0, 1 abstention.
12, 0, and 1. The bill is reported, and I believe, are we finished?
Never mind.
Okay, we.
Thanks.
Okay.
Thank you, Mr. Chairman. Thank you, everybody.
Yeah, Senator Peterson.
Mr. Chair, I had Senate Bill 1060, which is basically the equivalent of a Rule 41 dismissal. It's a great idea, but I just simply don't have time to discuss it right now, so I move that we carry it over to next year.
Senate Bill SB 1060 has been moved and seconded to carry it over for the year. All in favor of the motion, vote aye. All opposed, no. The motion.
Ayes 13, no 0.
Mr. Chairman. 13 to 0. The bill is continued for the year. Senator Morrissey has what?
Mr. Chairman.
What?
Over here.
Oh, yeah, Senator Chafin.
Yes, sir. Having voted on the prevailing side by which the vote was taken on Senate Bill 807, I move that we reconsider the vote.
So whose bill is that, 807?
807.
That was my bill, Mr. Chairman, and I failed to record Senator Serville's.
Okay, it's been moved and seconded to reconsider the vote by which we failed to pass Senate Bill 807. All in favor of the motion, say aye.
Aye.
Aye. All opposed, no. No. I'm sorry, you gotta vote aye.
Ayes 8, no 2.
Ayes 8, no 2. The bill is before us again, is reconsidered 8 to 2. All right. Now, it's before you.
Move to report 807.
Remind us again what 807 is?
807 was the bill where A person was convicted of a third offense, petty larceny, could not be sentenced to a class 6 felony.
Yeah, okay, all right. It's the three strikes you're out bill. Okay, this would undo the three strikes you're out. All right, all in favor of reporting the bill, has it been amended? All in favor of reporting the bill, vote aye. All opposed, no.
Aye, 6, noes 5, 1 abstention.
6, 5, and 1. Same results. What?
Oh, excuse me. I'm sorry.
Strike the bill, 'cause, all right. Strike the bill, start again. All right. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
You're voting up there. Senator Kenny, I know you're here, but he's got it.
All right, you got it.
Aye, 7, noes 5, 2 abstentions.
7, no 5, 2 abstentions, and the bill is reported. Well, good for you. Okay.
You can't vote against Joe. I don't know what the problem.
Okay, now, I believe, are we finished? All the bills and the docket? I want to, first of all, I want to thank Kristen Walsh, John Garrett, Charles Quigliato, Steve Benjamin. You guys have done a wonderful, wonderful job. And I know it's been hard. It's been, how many bills we had this year? 257 bills. And we made it on time. It's 10:30. The session starts at 11. Thank you all. Give them a round of applause. Stand up and give them a round of applause. Thank you all so much. And with that, the meeting is adjourned.